Hello and welcome to our very speedy summary of what is going to happen if you find yourself in a redundancy process. I'm Sarah Carpenter and I'm the Regional Secretary from the South East region, and I'm joined today by a number of my colleagues who I'm going to introduce shortly. But just wanted to say that we really are aiming to give you today a bit of a snapshot into some of the things that you might need to consider if you're faced with redundancy in your workplaces. Now, ultimately, our position is that employers shouldn't be making redundancies at this time. And if you hear about anything, you should get in contact with your officer as soon as you hear anything for some further advice. But hopefully what we've got to tell you today gives you a bit of an understanding about how the process might work. And that's the structure for today. We're going to talk you through what might happen at each point in time. And gives you a bit more awareness of what your employer might know, so that you're forewarned and forearmed in this scenario. We're going to be talking about lots of resources. There'll be links appearing to those as we go through, and everything will be put onto our website. And again, there'll be links to that. And I'll talk a bit more about further training later on as we go through this conversation. So how we're going to do this is a bit of almost like a panel discussion, as if you were sitting in front of us in a room and we were all at a table and giving some information. So if I can just introduce my colleagues who are going to be with me as part of this conversation and sharing information with you. So first of all, it's Bob Middleton, who is the Deputy Regional Secretary and the Regional Coordinating Officer for the Manufacturing Cluster. Hi,
Afternoon,
Bob.
Sarah.
We've also got Debbie Watson, who is the Regional Coordinating Officer for our Services Cluster. Hi, Debbie.
Hi.
Then there's Janet HENNEY, who is the Regional Coordinating Officer for our Transport and Food Cluster. So hi, Janet.
Hi, Sarah.
And then last but certainly not least is SHELLEY Phillips, who is our Legal Manager. Hi, SHELLEY.
Sarah.
As you can see, it's very odd. We're all talking to you from our own homes. But as you will appreciate, we're all working remotely at the moment, but coming together to give you this information. So really wanted to start off with a question to SHELLEY, because mostly the questions we get, first of all, about redundancy are very much the legalistic ones. So could you give us a bit of a summary of those key legal aspects around redundancy, especially right at the beginning of the process?
Yeah, so if we start right at the beginning of the redundancy process, I think the main thing that you need to be aware of is your employer's responsibility to inform the redundancy payment service, along with any recognised trade unions, of their intention to dismiss as redundant 20 or more employees at one establishment. So like I said, they have a duty to inform you of those redundancies, and the way that they inform both the redundancy payment service and the trade unions is by filling in what's called a HR1 form. Like you mentioned, Sarah, there's going to be some resources going alongside this video, and one of those resources is we're going to upload a blank copy of a HR1 form onto our website. So if there are any reps that have perhaps not been through the redundancy process before, they can have a look at this form so they know what to expect when they receive one from their employer. Now this form, just to give you an idea of some of the information that it includes, it's a short 2-page form, and it's got some information that the employer has to provide when they're informing people about making redundancies. So that information, they have to provide the employer's details. That includes the employer's address and their contact details. They have to provide information on the location of the proposed redundancies. They have to provide information on the timing of the redundancies that they're proposing to make. They have to provide information on the method of selection that they intend to use as part of the redundancy process. They also have to give a breakdown of the numbers of the potential redundancies and which part of the business those redundancies are going to be made. The HR1 form actually gives a breakdown, so it lists bullet points of different areas of business, and they have to put the numbers next to those areas that are specified on the HR1 form. They also need to give their reasons why they're making the redundancy, and they need to put information about who they're going to consult with as part of the redundancy process on that HR1 form. So that brings us quite nicely onto the next stage, which is once they filled in that HR1 form and provided it to the trade unions, they have an obligation to consult with the unions about the redundancies that they intend to make. So the main thing to remember is that this consultation process has to be meaningful. and it has to happen within good time and within a reasonable amount of time. So there are some minimum requirements in terms of how long the consultation process should take. So if employers are making between 1 and 99 employees redundant, then the consultation period has to last for a minimum of 30 days. If they're making 100 or more employees redundant, then the consultation process has to last for a minimum of 45 days. And it's important for reps to bear in mind that these are minimum requirements. So if the redundancies that the employer is making are quite complicated, or if they're making a really significant number of redundancies, it may well be that the consultation process will last longer than 45 days. And I would certainly recommend that it does if they're complex redundancies, because you need to make sure that you've covered everything that you need to talk about as part of that process. So again, the law sets out some kind of basic things that have to be covered as part of that consultation process in order for it to be meaningful. One of the most important things that has to be covered, and one of the main things that reps need to be thinking about, is the employer has to explain the reasons why they're making the redundancies. And it's these reasons that will help reps to determine whether or not the redundancies are genuine, and this is really important. So some of the most common reasons that employers make redundancies are potentially the whole business is closing. It might be that there's been a reduction in work and therefore they have to make a reduction in the workforce. It might be that they're restructuring and reorganising, and as a part of that reorganisation, some of the job roles are no longer required. It may well be that there's a TUPE transfer, and as a result of that, there's some redundancies. I think in the current circumstances, one of the most usual reasons we're going to see for redundancies is either going to be the business closing completely or a reduction in the number of work, meaning that they don't need as many employees anymore. Two of the other main things that need to be covered as part of the consultation process is that the employer needs to look at ways of avoiding the redundancies. If the redundancies can't be avoided, they need to look at ways of minimising the number of redundancies, and they also need to look at ways of minimising the consequences of the redundancies that take place. So they're the kind of key areas that have to be discussed and covered as part of the consultation process. As well as that, the law also sets out that there are certain documents and things that the employer has to provide in writing as part of the consultation process. So this includes, and apologies because this is going to be repetitive of some things I've already said, but they have to provide in writing reasons for the redundancies, the number of employees being made redundant and the description of those the types of employees being made redundant, the method of selecting those employees, the method of carrying out the dismissals and the timeframes in which the dismissals will take place, the proposed method of calculating redundancy pay, the number of agency workers that the employer has doing work for them, and the type of work that those agency workers are doing for them. So like I said, some of it is repetitive. You might have noticed that some of those things they have to provide in writing will have already been provided as part of the HR1 form. Some of them aren't covered in the HR1 form, so you'll need to get copies of that information in writing, and you may find the employer gives you additional documentation to back up some of the stuff that they've already provided as part of the HR1 form. They have to give this documentation to you within a reasonable amount of time, and they have to give you plenty of time to go away and consider it and then be able to come back and ask them any questions. If you find your employer hasn't provided any of this information, you need to make sure you're going back and getting it, because it's your right to have access to all that information that I've listed. And the other main thing to talk about just generally from the beginning is just to remember that these proposals that your employer is making, they're not set in stone. So that's the whole point of the consultation process. It's a two-way process, and the aim is for the employer and the workplace representatives to reach an agreement at the end of that process. And also as part of the process, you need to remember that you should be given access to the affected employees as well, and that's something that's important to remind your employer about as well.
Thanks, Shelley. Lots of information there to be really thinking about right at the very start of the process. So kind of putting a rep's hat on, it's good to hear from Janet next about what reps can and should expect to happen at the start of the process and what that initial consultation meeting should be looking like, bearing in mind that legal framework that Shelley's just given us.
Yeah, thank you, Sarah. So Shelley has taken us through a large amount of information that is a legal requirement for the employer to provide. Now, the important thing for reps to bear in mind here is that the first consultation meeting is likely to just be the first one of many consultation meetings, and indeed should be. This isn't about one meeting where reps are given all of this information and that's the end of the process. The first consultation meeting, possibly the first two consultation meetings if there are a longer series, are about the pieces of information that Shelley has listed, which are key for the reps to understand what the reasons for the redundancies are. It'll be a copy of the HR1 form, a very detailed explanation of the reasons of the redundancies. Now, this explanation is likely to have possibly some quite technical financial information in it, and the use of technical financial phrases. There might be lots of things in there about operating profits, turnover, revenue. Unite have got a handy glossary covering all of these terms, and that's going to be on our website along with the other resources that you've covered, Sarah. My recommendation to reps would be not only to have a look at that, but print a copy of that glossary off, take it with you to the consultation meetings. That way, as phrases are being bandied about by the employer in their explanation of the reason for the redundancies, you'll be able to keep up and know what's being talked about, and this is really important. So early on, copy of the HR1, detailed explanation of the reason for the redundancies, the schedule of the so-called at-risk pool. That's the list of people who are at risk of redundancy, and it needs to include both numbers and description of job categories. Also, the timescales that the company are proposing to implement the redundancy programme within, and the list of agency workers being used and description of the jobs that they're in. All of that information is really key to have at the start of the consultation process, because that's all information that's going to be absolutely necessary and critical really to meaningful consultation taking place. There was lots of other information that Shelley listed there. Some of that might come a little bit later in the process. So things like the selection criteria, things like the calculation of redundancy pay, they will also come in, but they may come in a little later. Those bits that I've just listed about the basic information are the key things that reps should be demanding right early on in the process.
Thank you, that's really helpful. And I suppose alongside all of that kind of real process stuff, there's some big jobs for the reps to do away from the negotiating table itself. So Bob, what kind of things do you think reps should be doing in addition to all of the things that we've mentioned before?
As we know, Sarah, with any redundancy situation, it can be an incredibly difficult time for our members, a stressful time. As reps, we all know the importance of feeding back information to members at their earliest opportunity. So, you know, reps will be organising meetings with members, whether that be branch meetings or workplace meetings. They will be talking to them about every discussion that's taken place and about where we are. It's also an opportunity, particularly if you're going to communicate with members by sending out newsletters, put an application form on the back of that, because where we've got non-members, as you know, the stronger we are, the stronger voice we've got. So we can use it as an organising opportunity, but we must communicate with our members by newsletter, by WhatsApp, by email, by text, to ensure that all of our members have all of the information and they're fully up to speed with where we are. Hopefully within our recognition agreements, within our redundancy agreements, there's a VR scheme, and we should ensure that members are fully aware of the terms of the VR scheme. And any questions that members have got, it's important that we feed them back to the employer. And as Janet has said, there will be many, many meetings in terms of the consultation process. So that's the starter really for ensuring that the members know exactly what we're doing and where we are in terms of the negotiations.
Thanks, Bob. And I think VR, voluntary redundancy, is something we're going to pick up a bit later on as well, because I'm sure people will have some questions about that. in terms of all of this, there's a lot happening very early on in the process, and I think it could be quite easy to get a bit lost and a bit overwhelmed by all of that. So it's a question for Janet of what do our negotiators need to keep at the very front and centre of their minds at this time?
One of the things I found personally really useful over the years of doing redundancy consultations is to go back to the principles around redundancy consultation and to really hold those in mind. So if we think back to what Shelley was saying in her opening remarks about the legal requirements, there are two real base principles here. The first one is a question of, is it a genuine redundancy situation? So is the business closing? Is a particular workplace closing? Has there been a diminished need for workers, whether through reduced production, restructure of the company, introduction of new technology and automation, etc., etc. So the first question to keep in your head is this really a genuine redundancy situation? And the second thing to keep in your head is a question about meaningful consultation. You know, the law is quite clear that the consultation shouldn't be a sham, it should genuinely be meaningful. And in order for it to be meaningful consultation, all of that information about the reason for the redundancies needs to be shared. And then the consultation needs to look at ways to avoid redundancies, reduce the number of redundancies, and also mitigate against any redundancies which are being made. So there's an awful lot of detail going to be shared with the reps at this time around the reasons for the redundancies, etc. If they keep these two guiding principles in mind and all of the information they're given, look at through the lens of these two questions, if you'd like, is it genuine and is this consultation meaningful? It's a way to not get lost in all of the information, but to keep some real guiding principles in your head. So when you're starting to put forward suggestions, for example, are they being taken seriously? Are they being dismissed out of hand? So, you know, is that genuinely meaningful consultation? And it's a way to just stop yourself getting lost, if you like, in all of the detail that's going to be shared with you.
Fab, you've mentioned an important point there about consultation needing to be meaningful. So given that it should be, and therefore a real two-way process between us as the union and the management, what kind of suggestions should the reps be taking to those consultation meetings, do you think? And Janet, if you could kind of give us a bit of information on that, that would be helpful.
Okay, well, it's actually a really, really difficult question, Sarah, and it's a lot more difficult than you might at first think, because it depends wholly on the reasons for the redundancies, which will have been provided by the employer early on, and also set side by side to the reason for the redundancies. It'll be governed by an understanding of the nature of the business and the way in which the business is structured. So in order to put suggestions forward, you need to know why the redundancies are being made, but also to have a very deep understanding of the way in which the business works, so that you can look at ways in which things can be done differently in order to avoid the redundancies or reduce, etc. So one of the that the reps will need to be doing at this time is, if the redundancies are relevant to areas of the business that they're not involved with themselves, they'll need to be talking to the members to make sure they get this understanding. And there's a really sound legal principle behind all of this, which is the people on the ground actually carrying out the job are very often the people who are best placed to be able to come up with suggestions about how things could be done differently in order to avoid the redundancies. So it's really necessary that that bit is understood in order to be able to take suggestions back in. Now, having said that it's very specific to context of the reason for the redundancies plus the structure of the business, some sort of general examples could be looking at, is it possible to restructure the work? Have the company stopped recruitment? And is it possible to retrain, redeploy people into those vacant roles? Have they stopped overtime to put those production hours back into core contract hours? Have they looked possibly at new shift patterns? And have they looked at refocusing the business to look at if there's different areas of business that they could move across to that will continue that business functioning? So, for example, if it's production of a certain widget, is there an alternative widget that they can move to that would allow business to maintain? So is there a possibility to refocus the business? If throughout these consultations it becomes clear that it just isn't possible to avoid the redundancies, then it is always a very, very central principle for Unite that any redundancies should be voluntary. So rather than the employers just moving straight to compulsory redundancy, they should always be looking for volunteers in the first instance. Also to be borne in mind is going back to the second principle about reducing the number of redundancies and minimising the impact. You know, if it gets to a stage where it's clear that there will be redundancies, how do we reduce that to make the most minimal number of job losses possible? Also at this point, they might need to start thinking about the redundancy pay. Is there a way that the reps can get the employer back to the table to look at negotiating an improvement in the redundancy pay package? They'll need to think also about a group of workers who get forgotten about quite often in this. We're focusing on redundancy, which is about people who are going to be leaving business. One of the group's workers who get forgotten about very often are those who are retained in the business. So in any redundancy situation, unless there's a whole business closure, there will always be people left behind, retained in the business, and the redundancies will by definition have an effect on them, because it may well be that those who are retained in the business are expected to pick up different ways of working, expected to pick up bits of work of people who have been made redundant if the company is being restructured. So reps also need to be looking at the impact and mitigating circumstances for those who aren't being made redundant as well. Ultimately, when it comes down to it, if there's no way of avoiding the redundancies, the reps then need to engage with the company on agreeing the selection criteria, because although the selection criteria is something that is applied to individual employees, it does need to be agreed collectively with the reps through collective consultation. Now, there are some quite particular areas that the reps need to familiarise themselves with around selection criteria.
Yeah, which is a handy point to bring Shelley back into this conversation, because while Janet's raised a lot of negotiating issues there, she has absolutely pointed it firmly at the legal points that need to be borne in mind at this juncture. So could you take us through what some of those are?
As Janet's mentioned, I think one of the important parts of the consultation process are going to be those discussions around selection criteria, and reps need to think really carefully about the criteria that their employer is proposing to use in terms of how they're going to select people to be made redundant. And the main thing they need to bear in mind is just making sure that that selection criteria is fair and that it's going to be applied fairly as well. We want to obviously make sure that it's applied fairly to everybody. If it's not, and the criteria isn't fair, you're going to have a situation where you get employees that are unfairly selected for redundancy, and as a result, their dismissals are likely to be unfair as well. So the whole process could potentially become flawed if the selection criteria is not fair. Like I said, you also need to make sure that the criteria can be applied fairly as well, and the employer needs to give explanations as to how they're going to apply the criteria. One of the main things that we need to be thinking about is making sure that the criteria doesn't give a disadvantage to particular groups of employees. Those particular groups that we need to be thinking about are any employees with protected characteristics. So those protected characteristics are age, sex, disability, race, religious belief, maternity, paternity, anybody on adoption leave. Those kind of categories are people that could potentially be at disadvantage when it comes to selection criteria. So we really need to bear that in mind. We also need to make sure that people who are working part-time or on fixed-term contracts aren't put at a disadvantage, and also making sure that trade union members and trade union reps as well aren't put at a disadvantage based on the selection criteria. So when thinking about this, I think one of the main things that reps can do to try and make sure that the criteria is fair is to make sure that it's as objective as possible rather than subjective criteria. The more objective the criteria is, the more fairly it's like to be applied as part of the scoring process. So to give some examples of the kind of good criteria that employers can use, things like skills and qualification, attendance, experience, performance, and knowledge as well. So of those kind of examples, you can see that, like I said, they're things that are quite easy to quantify. It would be easy for employers to point to the kind of documents and evidence they're going to use to back up how they've scored that criteria. So for example, if you look at skills and qualification, it's going to be easy for employers to say what they're going to use to create a scoring system for skills and criteria. The criteria that's more subjective are things like attitude towards work, flexibility, commitment, and these are the kind of things, we're not saying that they shouldn't be used, but if they are being used, because they're quite subjective, we just need the reps to be pushing the employer to be clear on how they're going to score things like this, because they're things that could potentially put people at a disadvantage. So if you look at a criteria, something like flexibility, this could potentially put women at a disadvantage if they've got children, because they're less likely potentially to be as flexible as others because of their care and responsibilities. So they're the kind of little things that you need to be looking out for. And like I said, it's not that those criteria shouldn't be used, but we just need really clear definitions of how they're going to be applied. And although objective criteria is better, that's not to say there aren't pitfalls with that as well that we need to look out for. So for example, if you look at something like attendance records or sickness as our criteria that could be used, again, it's fine for it to be used, but it could potentially put people with disabilities at an unfair disadvantage, and also potentially pregnant employees, because they're more likely to have been off sick more due to their disabilities or due to their pregnancy. So again, if we're using a criteria like that, we need to get assurances from the employer that any absences that were a result of things like that are going to be discounted when they're doing the score, because otherwise people are potentially going to be given a lower score, and this will result in them potentially being unfairly selected for redundancy, and again that means that the dismissal is going to be unfair. So like I said, it's just setting out, making sure the criteria is fair and objective, and making sure the employer is setting out clearly how they're going to be applying that objective or subjective criteria to the scoring system. So they're the things we need to be looking out for. I think we said already before, if reps have got any concerns about the criteria or anything that's being used, then they need to be contacting their officer, and we can get as much advice for them as possible during the process.
Thanks, Shelley. I think it's looking like we're getting to a real point in the process where decisions that are going to impact our members are really starting to be made. So Bob, if you could help us out here in terms of what reps should be thinking about in terms of the members that they represent at this point in the process.
Well, obviously, as Janet said, we would be pushing the employer to ensure that we've got a VR scheme in place. And if we've got a VR scheme in place, that members know what the terms are, they know when the opening and closing dates are. But if we're in a point where there are going to be enforced redundancies, then clearly the stewards need to be communicating through meetings with members, talking about what they can and can't do. Members are entitled to have suitable alternative employment at their firm, and there's a legal obligation for the employer to look for suitable alternative employment. If members are selected for redundancy, they do have a right to paid time off, to look for employment. They also have a right to request training. So these are the things that the reps will be looking at to try and support our members. You know, we all know, and those of us that have been involved in redundancy discussions, how incredibly difficult it is when you're going to lose your job. So members need to know that you're not the union going to be there to support them all the way. And if members are concerned or unhappy about the selection criteria, they have the right to appeal, and they have the right to have their shop steward who would represent them at that appeal. It's about uniting the union and ensuring that there's a fair process, as Shelley has gone through.
It's a really important point about the fact that the union is there every step of the way, and how important it is to have the union behind you, because there's so much to this. You know, you could get so confused trying to do it on your own without any union support. And it's even worse, I think, if we get into the point where, in terms of consultation, we've been talking about scenarios where there is some, but what if an employer doesn't consult, Shelley, and what's that legal remedy look like if they fail to consult?
Yeah, well, like we've said already, you know, there is a legal obligation for employers to consult when they're making 20 or more redundancies. But of course, there are always going to be scenarios where the employers don't consult on those redundancies. The most common occurrence when you see this happen is if an employer goes into administration, and on most occasions when that happens, there'll be no consultation that happens at all. And there's also scenarios where employers consult, but they don't consult meaningfully, or they don't follow enough of the consultation process. And there are legal processes that can be followed if employers are failing to meet their obligations. And the main route that we can follow is to pursue a protective award claim on behalf of employees or members. So a protective award claim, essentially, like I said, it's a claim that's pursued where employers fail to consult properly on redundancies. The maximum award that can be granted for a protective award claim is up to 90 days pay. So the amount that's awarded if the claim is successful will vary depending on how much consultation has taken place. So for example, if a company has gone into administration and no consultation has taken place, and we were running a protective award claim for the members affected by that issue, we would be hopeful that the tribunal would award the maximum amount of 90 days because there has been zero consultation. For all other circumstances where there may have been some consultation but not enough, if the claim is successful, then the award that's given by the tribunal will vary between kind of that 0 up to 90 days, depending on the level of consultation. So certainly, you know, there are consequences for the employer if they fail to consult, and we'll certainly pursue those claims if we have employers not meeting their obligations. In terms of not so much kind of the consultation process, but Bob mentioned a little bit before, in terms of individual issues regarding redundancy, there are other claims that can be run in the employment tribunal. So if, for example, we've got scenarios where the consultation process has taken place, but members at the end of it don't get their redundancy pay that they're entitled to, their statutory redundancy pay, then we can pursue redundancy pay claims for those members in the employment tribunal. If members have got a contractual right to enhanced redundancy, so above the statutory redundancy they're entitled to, and they haven't been paid this contractual redundancy pay, then again, those claims can also be pursued in the employment tribunal. They would be breach of contract claims, and there's a cap on those claims, so of 25,000. And again, the one we've already mentioned is obviously if we get to the end of the redundancy process and members feel that they've been unfairly selected for redundancy, there is a potential to pursue unfair dismissal claims if we believe that members have been unfairly selected for redundancy. So if employers aren't doing what they're supposed to be doing, then there are lots of avenues for that to be pursued legally, and Unite will obviously do as much as they can to support all of those claims where possible.
Thanks, Shelley. At the end of all of this process, there's obviously going to need to be some direct conversations with members on an individual basis. So I wanted to bring Debbie in here in terms of how will that happen, and will members get paid to attend those conversations with their employers, and what support should they be expecting that they get offered to find other jobs?
Okay, well, first of all, it should happen in working time. So whenever you are at work, you should be paid to attend. So if you're a night worker, then they should do it during a night shift. If that can't happen, they should facilitate you to have time off your night shift to then come in during the day. So that's really important. And this is your opportunity to find out how this affects you. So that could be anything from, if it's the whole site closing, is it going to be in phases? If so, at what point is it going to impact on you? If it's not the whole site, that's when you can talk about, really, is this really affecting me? Do you think this is the way we're going into pools? Am I doing the job that's at risk? It's one of the things that we find often job descriptions have evolved over the years, and people might find that they've got the wrong job description lodged in their HR file, and actually they may feel they're not affected. So really it's your opportunity to ask as many questions about this as possible. I would say there isn't such a thing as a stupid question in this process. Ask away, bombard them with lots of questions, get as much facts and figures from them as possible, because if you are going to appeal later down the line, the more information you can get at this stage, the better. And really, it's your opportunity to share your concerns, any bright ideas that you may have come up with that may save your job or colleagues' jobs as well. And also, it's a good opportunity to talk about suitable alternative employment. It could be that you've got a hidden talent that your employer is not aware of. For example, you could be on the shop floor, but really be a fully qualified HR advisor. Now's a good time to tell them that, because they may not be calling the HR department. So you need to be very clear on what you are able to do. When it comes to suitable alternative employment, that should be within your current contract parameters, so hours of work. But again, if you're flexible, it may be that if you're willing to reduce your hours, and that could save your job because you'd rather have that than be made redundant, now's a good time to say. So it's about you being as open with them as possible, without getting rid of your contractual rights. Does that answer your question?
I think that does, Debbie. Thank you very much. And that kind of takes us into, I think, what some legal advice might be for individuals in this position. So Shelley, can you enlighten us a bit on that?
Yeah, so I think in terms of legal advice for individuals, I think it comes back to something that I've talked about already, which is the selection criteria. And also there probably needs some legal advice around the stuff Debbie's talked about in terms of suitable alternative employment. So going first to the selection criteria. So I think the main thing that reps need to make sure that members understand is what options are available to them if they feel that they've been unfairly selected. Now, I think that what reps will probably find is that once members start to have their individual consultations, they may well have a lot of members coming to them saying they feel they've been unfairly selected. So I think, first of all, reps need to be realistic about what being unfairly selected is. So if you've got members who are unhappy with their score, but even if their score was increased slightly, they're still likely to have been made redundant, then we need to be realistic with those members and manage their expectations. If we've got members who feel they've been scored unfairly and their score is kind of borderline, where potentially if it was changed slightly, it would mean that they wouldn't be made redundant, then we perhaps need to be drilling down in more detail into their scores and making sure that the selection criteria has been applied fairly to them. So I think members need to be aware, like Debbie said, that initial interview that they have, if they're not happy with their score, they need to make it clear during that interview that they're not happy with it, and make sure the employer is explaining to them the reasons behind their score and what information was used. If they decide to appeal the redundancy decision, again, they need to be raising why they're unhappy with their score and why they've been selected as part of that appeal process. If their score remains unchanged and they're still made redundant, then those members do have the option at looking to run an unfair dismissal claim if they feel they've been unfairly selected. But again, we need to be really clear and realistic with members that those claims are difficult to run. If it's really difficult to challenge selection criteria unless there's really obvious evidence of bias or manipulation or a fundamental flaw within that whole process. And probably in a lot of our organised workplaces, there shouldn't be any of those big issues, because hopefully during consultations we would have been involved in putting all that criteria together and making sure that it's applied fairly. So we need to manage members' expectations, but just let them know that they can appeal. And if they're unhappy with their score, we can look at it, and we'll drill into it a little bit more to see whether there's potential to run an unfair dismissal claim for them. And like I said, like we talked a little bit about before, I think the main thing we'll be looking at is potentially criteria that's been applied if it's more subjective criteria, and how the scoring's been used. So they're the kind of things that reps need to be looking out for, essentially, as part of that individual consultation process, and where members are kind of unhappy with their score. In terms of suitable alternative employment, like Debbie mentioned, as part of the consultation process, employers have to offer or attempt to offer suitable alternative employment to everybody. If your employer fails to offer suitable alternative employment when there was alternatives available, then it may mean that your dismissal is unfair. So it's really important that employers are looking to see what alternatives there are, and making sure they're made available to anybody that's going to be made redundant. Any suitable alternative employment, the offer of it must be made before the contract ends, and the alternative employment must start within 4 weeks of the end of the contract. And members do have the option of trialling a suitable alternative employment before committing to it. So they can trial it for up to 4 weeks, or possibly longer if they get written agreement with their employer that they want to trial it for longer. And by signing up to a trial, it doesn't mean that you're opting out of receiving your redundancy pay if at the end of that trial process you decide that it's not suitable and it's not reasonable for you to accept that offer of alternative employment. In terms of where the reps fit into this, one of the things that's really key is, like I said, employers have a responsibility to make members aware of suitable alternative employments and any vacancies. It's not enough for the employer to just be posting jobs onto notice boards. This is potentially unfair for members or employees that aren't in the workplace. So anybody who's on maternity leave or on sick leave, they're obviously not going to be able to see those job vacancies that are posted. So employers need to be taking those vacancies to the employees. One good exercise for the reps to do is often to make sure that they're aware of all the vacancies within the business, so they can be making sure as well that members are aware of them, and pushing the employer to be raising certain vacancies with certain members depending on whether it fits their circumstances. So it's definitely a good exercise to make sure they're familiar with the structure and any vacancies that there may be. In terms of legal claims that may come out of the situation for suitable alternative employment, like I said, if there's suitable alternative employment and your employer fails to offer it to you and you're then made redundant, you could potentially have an unfair dismissal claim because your employer failed to give you that option. The other claim that you can potentially see is where an employer offers a suitable, what they believe to be a suitable alternative, and an employee rejects that suitable alternative. If the employer believes that it's suitable and the member rejects that offer, and the employer thinks it's unreasonable for them to reject it, they could potentially be not entitled to their redundancy pay. So these can be quite complex claims, and it's quite a risk potentially for members to be unreasonably rejecting suitable alternative employment. In terms of those claims, it kind of comes down to two parts: whether the role that was offered was genuinely suitable, and whether the member was reasonable in rejecting it. So whether or not an alternative is suitable, there's not kind of a one answer fits all to this, but some of the main things certainly that the tribunal looks at and thinks about in terms of whether a role was suitable are things like job content, so whether the content was similar to the role the person was doing before, the status that comes with the job role, so whether it's a similar level of status in terms of whether you were a manager before and are you continuing to manage people going forward, what pay the role comes with, the kind of benefits that the role comes with. So this isn't an exhaustive list, but it's just an example of some of the things that can affect the decision of whether or not a role is suitable. And then the other part of it is whether or not the person was reasonable in rejecting that job offer. And again, there isn't a one answer fits all. So, one person rejecting a role might be reasonable because they've got particular individual circumstances. Somebody else rejecting the same role may not be considered to be reasonable if their personal circumstances are different. So for example, if somebody is offered an alternative and the hours are different, and that person has caring responsibilities and they therefore don't think that they can change their hours to fit with that role, that's likely to be a reasonable reason for rejecting it. If you've got somebody that doesn't want to do the change in hours because they don't want to be travelling in peak rush hour, so they just don't want to do that job, that's likely to be unreasonable. So same kind of people that were previously doing the same job being offered the same alternative, but different scenarios in terms of whether or not their rejection was reasonable. So this is quite a complicated and complex area. I don't want to go into it in too much detail, but it is a question that could potentially come up quite a lot in terms of when these individual consultations start. My main recommendation would be for reps to keep in touch with their officers. If they've got any scenarios like this coming up, flagging it up with their officer as soon as possible so officers can seek to get legal advice on the matter, but just making sure that they're making their members aware of the risk when it comes to turning down suitable alternative employments as well. And the other thing as well is making the employer aware that you know, it's up to the employee to decide whether or not something's suitable. So an employer can't not offer something to an employee on the assumption, well, I don't think they would take it because it was on a grade lower. They've got to let the employee make that decision. So the employer needs to be aware of the risks as well when it comes to what they should and shouldn't be offering. So like I said, it's quite a complicated area. Always make sure you're talking to your officer at all times when it comes to things like this. I think they're the kind of the main things when it comes to those individual consultation meetings, but I'm sure there'll be other questions that reps will potentially be raising with us, and hopefully we'll be able to address them as and when it's needed.
Thanks, Shelley. I think now we've kind of gone through a lot of where the process is going to take us. We're right at the end of that process now, and it's a question for Debbie really of what happens after the decision to make somebody redundant happens. What will they get paid if they're made redundant? It's really right at the end. What are the expectations going to be?
Well, first of all, everything should be communicated to you in writing. So if the worst has happened, you're made redundant, you've exhausted all your rights of appeal, you're then into how much money you're going to get, how much notice. Now, there are minimum statutory payments, but your reps may have negotiated a better package. But the minimum that you should get is based on complete years of service. So I'll talk about timings in a minute because timings are really important. So this has got to be full, complete 12 months of service. It's 2 years minimum, so you need 2 years minimum employment to qualify for a statutory payment. And then, this is where it gets a bit complicated, you get 1.5 weeks for each full year of service if you are 41 and over. For those years of service between the age of 22 and 41, you'll get 1 week. And then for those before the age of 22, you'll get half a week. And it's a maximum of 20 years service that you'll be calculated on. And there's also a weekly pay is today defined as £538. That's the cap. And that's the statutory payment you would be entitled to. Now, there are lots of calculators online that you can go and use at that point. Now, hopefully your reps will have done a great job and negotiated something more. Now, what a lot of people do, they get rid of the statutory cap or they give you an extra few years, but let's hope it's more. But if not, those are the minimum you're going to be entitled to. You're also entitled to minimum notice periods, and that will be whatever is in your contract of employment, or 1 week per complete year of service up to a maximum of 12 weeks. So again, you need to compare your contract, compare to what may have been negotiated, and put that near the statutory, what you're entitled to as a statutory minimum. If you've got any queries about that, that's when your full-time officer will be able to help you, because it can be quite confusing in terms of what's the minimum you're entitled to by law, and also what you're entitled to by contract. Your notice period, and this is where timings are everything, because if you are very close to a full year of service, and redundancy is based on your last working day, you might want to cling on and work as much of your notice or all of your notice, because that could tip you into another year, and that another year could make and give you an extra week's money. It could give you even an extra month's money, depending on how generous your scheme is. However, beware of pay in lieu of notice, and I know if Shelley's got anything to add on, pile on and pay in lieu of notice. They can do it, particularly if there's a clause in your contract. yes, you will still get what you're owed up to the point of your last day of employment, and any holiday pay that you be owed, but it could affect things like pensions and any other benefits as well. It's often better to work your notice or a combination of. These are things you need to take a view on, and you need to look at on an individual basis, seek advice on, and it also depends on how generous your employer is.
Thanks, Debbie. I think there's lots of stuff in there that probably when you're listening as a rep to this or as a member, you'll be wanting to think about your personal circumstances and getting some more advice. So as we've said throughout this, the important bit is absolutely seeking advice from your officer if you need to, just to make sure you're getting the right information. So a final question really on all of this, Bob, because given everything we've said, it's clearly being a member of a union is important. So what should individuals do about their Unite membership throughout this and towards the end of the process?
Well, I think it's important that the South East Legal Services Coordinator can visit the site and can meet with members that are being made redundant. We can offer financial advice, we can offer legal advice, and we also give a work pack out with an application form in there which members can fill in if they want to continue their membership. We believe it's vital they do, because they need to continue to be a member of Unite when they move to their next job. And for £2.38 a month, they can reach into a lot of the services that we can provide in supporting people, whether they're in work or outside of work. So it's vital that people retain their membership, and that's what we can do. And it's vital that people know that Unite Union are going to be there, whether they're in work or whether they're not in work.
Brilliant, thanks, Bob. And every one of my colleagues today has mentioned a lot of other resources, and Bob mentioned our membership rates there. Everything that we've talked about today will be put on our website, and there'll be links put into this so you can get the information that we've referred to, all of which is really important. The website will be continually updated, and so everything on there will be absolutely accurate. I wanted to say a big thanks to all my colleagues today for their time and for giving us the benefit of their experience and wisdom. And I think we've stressed throughout that if you have any queries, go back to your officer. Don't struggle with this on your own. We're here to help at every point. Unite is with you every step of the way, and what we are going to be doing is fighting for every job. We know at the moment it is a really difficult time for everybody in their families and their communities and in their work, and that's why Unite is here for you now and for all the time. So thank you for listening, and I hope you found our time today useful. Thank you.